Can a 10-year-old sell a house or a drunk person sell you a land? Let us find out who the law considers fit to make contract. Hi, I'm Ashi Kanchandani and this is Logical Lens, and here we connect law to people one basic at a time. And today we are decoding the capacity to contract to let us find out simply, easily and logically.
Capacity to contract simply means the legal ability to enter into a valid contract. If you don't have this legal capacity, any agreement you make is either void or voidable. Section 10 of the Indian Contract Act says that for an agreement to become a contract, it must meet certain conditions. First, it must be made with free consent of the parties. Second, the parties must be competent to contract. Third, it must be for a lawful consideration and lawful object. And finally, it should not be one of those agreements that the law declares void. Today, we're focusing on that second requirement, being competent to contract. Section 11 tells us that every person is competent to contract if they are of the age of majority, of sound mind, and not disqualified by any law. Anyone who doesn't tick all three boxes is not legally competent to contract. So, who's left out? Three categories: minors, persons of unsound mind, and persons disqualified by law. Who is a minor? A minor is someone who hasn't yet turned 18. Section 3 of the Indian Majority Act, 1875 makes this clear: anyone domiciled in India is a minor until the age of 18. A minor's agreement is void right from the beginning, or void ab initio. This was firmly established in the landmark case Mohiri Bibee vs. Dharmodas Ghose, decided in 1903, where the court held that a minor's contract has no legal effect whatsoever from the start. Exception: guardian's contract. There is an important exception though. If a guardian enters into a contract on behalf of a minor, and it's for the minor's benefit, then it can be valid. In Indrani's case, the court upheld such a contract because it protected the minor's interests. For example, a guardian leasing farmland for the minor's benefit is perfectly legal. Next, even after turning 18, a person cannot ratify a contract they made while still a minor. In Suraj Narain vs. Sukhi Ahir, the court held that a contract entered into during minority cannot be approved or confirmed later. Now, what if a minor borrows money or gets goods and then refuses to pay? The equitable doctrine of restitution says, if the goods or property are still with the minor, they can be taken back. But, as seen in Leslie vs. Sheill, a minor is not personally liable to repay money that's already been spent. Estoppel usually stops someone from denying what they've previously said, but not in the case of minors. Even if a minor lies about their age to enter into a contract, they can later plead that they were a minor. The law prioritizes protecting minors over protecting the other party. No specific performance. A court will not order a minor to carry out the terms of a contract. For example, if a minor promises to sell a bicycle, you can't get a court order forcing the sale. No vicarious liability. Minors are not vicariously liable, and their guardians aren't liable either, unless the guardian personally made themselves a party to the contract. For instance, if a minor damages something in a shop, the guardian isn't liable unless they specifically guaranteed payment. Necessaries supplied to minor. Finally, Section 68 of the Indian Contract Act says that if someone supplies a minor with necessaries, things suited to their lifestyle like food, clothing, education, or medicine, they can claim reimbursement, but only from the minor's property, not from the minor personally. Who is a person of unsound mind? A person of unsound mind is someone who can't understand the nature of the contract or make rational decisions about it. Section 12 says that a person is of sound mind if, at the time of making the contract, they can understand it and form a rational judgment. Contract with unsound mind, void. If a person is permanently of unsound mind, any contract with them is void. For example, a sale deed signed by a person with a serious, permanent mental illness will have no legal effect. Temporary unsoundness, voidable. However, if the unsoundness is temporary, for example, if the person was drunk or under extreme emotional stress at the time, then the contract is not automatically void, but voidable at the option of the affected party. Burden of proof. In Chacko vs. Mahadevan, the court made it clear, if you're claiming that someone was of unsound mind when the contract was made, it's your responsibility to prove it. Who are disqualified by law? Even if someone is an adult and of sound mind, they can still be barred from contracting if the law says so. The main categories here are alien enemies, convicts, insolvents, foreign diplomats, and certain corporate bodies. Alien enemy. An alien enemy is a person from a country at war with India. Any contract with such a person is prohibited during wartime. Convicts. A convicted criminal cannot enter into contracts during their imprisonment, but regains this ability after release. Insolvents. An insolvent person loses control over their property once declared insolvent, so they can't enter into contracts about that property until they are discharged. Foreign sovereigns and diplomats. Foreign sovereigns and diplomats enjoy special immunity. You can't sue them or contract with them without the consent of the central government. Body corporate. A company can only enter into contracts within the powers given by its charter or memorandum. If it acts beyond those powers, the contract may be ultra vires, and therefore invalid. So, to sum it up, a person can enter into a valid contract only if they are a major, of sound mind, and not disqualified by law.
So that was a wrap on capacity to contract. Don't forget to like, share and subscribe to Logical Lens. Stay curious, stay legal. Until next time.